The petitioners have filed these writ petitions to quash the impugned show cause notices without appearing for the personal appearance and without submitting their explanation. The main plank of the contentions of the petitioners is that the first respondent government is not the competent authority to issue the impugned show cause notices. According to the petitioners, the district collector is the competent authority to adjudicate the issue as to whether the petitioners failed to undertake mining operations for a period of 2 years after the execution of lease deed, and thereby the lease shall lapse thereafter if the decision of the district collector is an adverse one. The petitioners have an appellate remedy before the appellate authority. Hence, the first respondent is not the appropriate and competent authority to issue impugned show cause notices and making the allegations contained therein. The petitioners also stated that while the show cause notices relied on the reports of the inspection teams that inspected the quarry sites, the same were not furnished. The impugned show cause notices also referred to the reports of the district collector, that is, based on the reports of the inspection teams. The report of the district collector were also not furnished to them. Moreover, the impugned show cause notices also refer to the letters of the Commissioner of Geology and Mining, at the same were also not furnished. Hence, according to the petitioners, the impugned show cause notices have to be interfered with. The petitioners also stated that the inspection teams made surprise inspections without putting them on notice, and the petitioners were not present at the time of inspection, and the show cause notices based on such inspection reports are bad and illegal. The petitioners also pleaded that the impugned show cause notices predetermined the issue, that the petitioners violated Section 4A (4) of the Act, and the show cause notices are mere empty formality. When these writ petitions were posted for admission in the motion list, this court heard the learned senior counsel for the petitioners as well as the learned special government pleader for the respondents and reserved orders. The learned senior counsel for the petitioners made the following submissions. The first respondent has no jurisdiction to issue impugned show cause notices under Section 4A(4) of the Act, and on the other hand, it is only the district collector who can adjudicate the issue, and thereafter there is an appeal remedy. The following decisions are relied on in this regard for the proposition that if the statute prescribes an authority to decide a particular issue, only that particular authority shall decide the same and not some other authority or higher authorities. S. Kumaran versus Karnataka State Road Transport Authority, 1986 (1) SCC 357 para 15, and Manohar versus Unni Krishnan, 2012 (11) SCC 437 para 23. As a corollary, it was submitted that when the statute mandates the things to be done in a particular way, those things should be